SJC-12222, George T. Koshy v. Anupam Sachdev.
Good morning. Chief Justice
Good morning, Mr.
Gantz,
Waters.
Justice of the Court. My name is Charles Waters. I represent George Koshy, who's the appellant in this action. Mr. Koshy is the co-founder of a small 30-year-old software company located in Concord, Massachusetts called InduSystems. He started the company from the basement of his house with his once close friend, Anupam Sachdev. The two of them have been the only two directors and the only two 50% shareholders that the company's ever had. Unfortunately, over the last 10 years, the once amicable relationship between the two has been replaced by disagreement on nearly every aspect of the operations of their company. The trial court found that that disagreement led to and caused distrust and an unwillingness to compromise on basic issues.
Except that the judge was really focused, I think, on the fact the company continues to do really well.
He did focus on that, and I think...
And then, so how can there be this big a problem, I suppose, is what the underlying insight is, if they can still manage to keep it going so well?
That's right, Your Honor, and I think that was an error for two reasons. First, the judge focused on this notion that the company was profitable, the company was ongoing, was a going concern.
Mm-hmm.
There are two problems with that. The first problem is that it ignores the comments that the legislature provided to the courts relating to the statute. And specifically, the one comment that I'm referring to says that you can have a deadlock company even if it's profitable. And that's an important concept, because this notion that simply because it's an ongoing entity, simply because it's continuing business is profitable, is reason for the finding that there's no deadlock, is inconsistent with these comments. The second reason is the plain language of the statute itself. The statute doesn't call for only cases of irreparable injury. Instead, it identifies the threat of irreparable injury. In other words, before a company is not functional, before a company becomes non-profitable, that's the reason for the language in the statute itself that includes threat. And there's one practical aspect too, Justice Lank, relating to your question, that I think it also provides good support for our position. And that is that if this statute only permitted companies that were not functional or not profitable to use it, it would never have anybody using it, because companies that are insolvent or companies that are not profitable or distressed usually go to the bankruptcy court. And very few companies that are distressed or insolvent would ever file a claim under this statute and litigate issues relating to this and spend additional money that the company doesn't have. So for those three reasons, we think that resting on primarily the notion that the company is an ongoing concern as the reason for no deadlock is an error.
So there are two questions. One is, it seems to me the judge also made a finding that there's no threatened injury, right? So it's not just that there isn't actual injury, but he also made a seemingly a fact finding as to no threatened injury. And secondly, I guess I question how much of this lies within the judge's discretion. Because even in that Delaware case that amicus has brought to our attention, it was considered to be not an abuse of discretion for the judge to go the other way. So, I mean, how much of this is a discretionary call on the part of the judge?
Well, Your Honor, there's two aspects to the statute, as you know. There's the first aspect, which is whether there was a deadlock among the management. The second aspect, whether there was a threat of irreparable injury or irreparable injury. On the first one, I think both parties are in agreement that it's a de novo review. There were findings of facts, and these were subsidiary facts found by the judge. We're not challenging those facts, but we believe the application of those facts to the statute was an error.
Is it error, as an abuse of discretion error, or what kind of error? Error as a matter of law? What kind of?
Yeah, the application of the subsidiary facts to the law was inconsistent with the standard that the statute sets forward. So in other words, the statute sets forward what is a deadlock and what should be a deadlock and what should be irreparable harm or threat of irreparable harm. And our position is that the subsidiary facts, as applied to the law, is inconsistent with the standards, and that, in fact, Mr. Koshy was entitled to relief under the statute.
So the question is, the injury has to be to whom? It has to be to the company, or it has to be to the shareholder bringing the shareholder, or, you know, whatever, I don't know, who is entitled under the statute to bring the cause of action?
The statute doesn't say who's entitled to bring the cause of action. It talks about irreparable injury, but it doesn't speak directly to who suffers from the irreparable injury. In this case, when you have a two-director company, that's also a 50% shareholder company, and these are the only two that make the day-to-day decisions on every aspect of the company, and the two of them don't agree on virtually every aspect of the company, and that disagreement has led to distrust and an unwillingness to compromise, I think it's clear that the harm is the distrust and the unwillingness to compromise, and that's suffered by the company because its two decision makers can't agree on anything.
I understand that, and I think that the thing that's really odd about this is that we have the two equally weighted owners, one of whom seems quite content to let this dysfunctional company, in that sense, go forward, and the other one who's dissatisfied. So is the harm to the company? Is the harm to Mr. Koshy?
Well, the harm would be to the company itself. But specifically, that harm runs through that relationship. So the relationship between, and let me back up a bit, because we've identified 4 or 5 different harms that we're saying were either actual injury or a threat of injury. But the most prevalent to me is the toxic relationship one. And the toxic relationship one is the distrust and the unwillingness to compromise on any issue. And to me, that harm is to the company when its directors refuse and cannot compromise on issues, because we know in the future, the next 15 issues that they need to make a decision about, they won't come to any agreement on. So, and we know it's irreparable because there was a finding saying that the parties are fairly well entrenched in their positions. So there was a finding that the harm, being the distrust and the unwillingness to compromise, is irreparable because of their entrenched positions.
See, that's the challenge, though, because your opposing counsel is going to stand up and say, what you're really doing is saying you don't like Judge Henry's findings of fact from the evidence. And if we take your findings of fact and apply them to the law, then clearly you've got the discretion, at least, for dissolution. But Judge Henry's findings are not consistent with that last point. He thinks that they can work together, that there can be a level of trust, that they do cooperate as it relates to pay raises and employees, and on and on and on. You can go through the catalog that they're going to go through, inconsistent with that position. So now we're left in a very difficult position of saying, if we take Judge Henry's facts, not your facts, and apply them to this dissolution statute, what's the standard when it's discretionary anyway?
Let me be very clear. We're not challenging Judge Henry's findings of his subsidiary facts. We are challenging his application of those facts to the law. Now, to your point, Your Honor, Judge Henry did not find a list of things that they disagreed on. In fact, one of the most notable things about this decision is it identifies literally dozens of areas on which they disagree, and then concludes with this sentiment that they disagree on virtually every aspect of the company. And in an 8-day trial, with discovery that lasted a year, and with one of the most important points being whether or not there's disagreement on any aspect of the company, only 2 findings of facts on minor issues were found by the court in its entire decision identifying any agreement. And one of those issues was a 2012 raise to employees. And the other issue, ironically, was a supposed agreement relating to hiring additional salespeople. The interesting part about that second supposed agreement is that the judge immediately found that they never hired any person, and they disagree about why they didn't hire the person. So we have one finding of fact, Judge Lowy, one finding of fact in the whole 8-day trial about an area they agreed on. So I would say that we want to use the judge's subsidiary facts because we don't challenge them. We believe that they're accurate, but applied to the law, applied to the statute, which no appellate court has ever done, we believe that the judge's findings were not consistent with the ultimate standard that this statute provides. And I would point to, I think, the comments as the most telling reason why the judge erred in his decision. Because you all saw that Judge Henry identified in his decision a comment section. And when you review the comments, 3/4 of the comments identify the cautionary terms and the cautionary comments that the legislature has for the use of this statute. And they say in three or four different ways, this statute should not be broadly used, only for true deadlock, it states. We're concerned about these following issues. And so for 3/4 of those comments, the legislature set forth a very compelling reason why trial courts should not be using this statute frequently. But what's most important is that immediately after that, it identifies one time, the one area where it thinks, and I quote, it was a particularly important remedy to use. And that one area, as the legislator identified in the comments section, is when there's a small company and you have 250% shareholders. That's this case.
Let me ask you about two determinations by Judge Henry, that there was a legitimate business reason not to have distributions, and that Mr. Sachdev was acting in the best interest of the company. What do you do with those two findings by Judge Henry?
Well, Your Honor, that relates to the breach of fiduciary duty claims. And our breach of fiduciary claims are concerned with those findings, are that he doesn't identify a couple of things. He doesn't identify what the legitimate business interest actually was. So that analysis is totally omitted. It doesn't identify the reasonable expectations of Mr. Koshy, and ultimately makes a conclusion that's not based on any of that analysis. And that's relating to the distributions. Relating to, because there are two facets of the breach of fiduciary duty appeal that we're pursuing. One relates to the distributions. The other one relates to this lowball offer that Mr. Sachdev made in the context of attempting to freeze him out in other manners. And we provided the figures in the brief. The company was valued by Mr. Sachdev for $15 million. It was offered to be purchased by a buyer for $7.2 million, just a year or two prior to Mr. Sachdev making an offer to buy out my client at essentially $285,000. And as the court knows, pursuant to Donahue and other cases, the freeze-out, the capstone of a freeze-out is the offer to purchase at a lower equity. And that was a capstone to this freeze-out, Your Honor, is that there was an offer to buy what was a lowball offer. And this was not an arm's length commercial transaction. This was between two owners of a closely held corporation. And the interest that they owe was the best interest for each other, and that was breached with the lowball offer.
Can I ask you, though, I mean, do you really need to have breaches of fiduciary duty in a close corporation like this, or freeze-out efforts or anything like that, in order to have a deadlock? Can you not have people with legitimate business reasons for the decisions or positions that they take that will be inextricably opposed to each other, and have that constitute deadlock?
I don't think there is any limitation in what a court would consider as part of the deadlock. Certainly, allegations of breach of fiduciary duty and lawsuits that are filed,
That can be evidence of it.
they can be evidence of it.
But I guess my point is, do you need that
You
in
don't
order
need
to establish deadlock? I'm trying to explore, what does deadlock mean?
Well, if you looked at the dictionary, and I did, and I chose Merriam-Webster's, the Merriam-Webster's dictionary says that a deadlock is a situation when two people cannot agree on a matter and refuse to give in. That's the plainly worded definition from Webster's. But a deadlock, to me, is when there's harm done that's not easily repaired. And in this case, the harm is not being able to agree on virtually every aspect of the business. That's caused distrust, that's caused an unwillingness to compromise. That's led to things like multiple lawsuits. There were 3 lawsuits at the time of trial. There are 6 now between the parties. There's a lawsuit in India that directly arose from their disagreement about how to pay their sister company, their back office, they call it, a company called E-Systems. There's an employee at Indus Systems right now that has been hired unilaterally, fired unilaterally, hired back, fired again, hired back. He sits there, he's an employee today. Somebody's wrong about that. He either shouldn't be there or he should be there, but he endures daily threats of being fired. And if he shouldn't be there, the company's paying him.
Well, if one person is, if one of the shareholders is being outmaneuvered by the other, I mean, if you look at it that way, is that really what the deadlock statute is meant to solve? One shareholder's ability to outmaneuver the other, because decisions are being made, obviously. Money is being made. So do we have a situation of outmaneuvering one of the other, and that's not really what the statute is intended for? I don't know.
Well, I think when you look at, for example, the Shaw case that was in the amicus brief, there is a history of the two of them trying to outmaneuver each other, hiring or having different people within the company work for them for their own personal agenda. So the answer to your question is yes. The court should look at whether the two are attempting to outmaneuver each other as a factor in its analysis about whether there's a deadlock. So the statute is not for somebody who's been outmaneuvered, but the outmaneuvering and efforts to outmaneuver the other is a factor that the court should look at in its analysis of the deadlock.
Yeah, but in the Shaw case, the trial court ordered the dissolution. What we have here is that the judge did not, and we have a statute that even if the prerequisites are satisfied, it's still within the purview of the judge to determine whether or not to order dissolution. That is a very markedly different procedural posture than the Shaw case.
Well, it is, and I'm not referring to the procedural aspect of the Shaw case. I'm just referring to the maneuvering aspect.
What do we do with the may part? What do we do with that? Is that an abuse of discretion when there's not even a requirement to order dissolution if the prerequisites are satisfied?
What I think you do is you look to determine whether the judge, in its subsidiary findings, applied the law correctly. Here, because he focused on the comments section on all of the areas where the legislature identified skepticism about an overuse of this statute, rather than the one area that he should have focused on was when it says that this statute is particularly important for cases like this. The fact that the trial court, with no appellate guidance, was focused more on these cautionary comments that were broadly worded and said that the statute should not be used too broadly, and then identified the reasons and didn't focus on the one comment that actually applies to this case, is an example that the trial court didn't have appellate guidance in situations where there's a subsidiary finding of deadlock together with a finding that they distrust each other and they can't compromise. And anybody that has seen a small company with 2 directors, 2 shareholders, not being able to agree on anything, know that that's the harm itself, is the distrust, is the unwillingness to compromise. And you know that it will never get better. And I think that's one thing that this decision was enlightening about, is that there is nothing in this decision about these 2 parties ever being able to compromise. It left off with a general finding that these two cannot compromise, and there's no resolution in sight. There's not a light at the end of the tunnel. The light at the end of the tunnel is decision by litigation, and that's what we're seeing, decision by litigation. And these two, for example, there's $1.5 million in retained earnings right now sitting there that they can't agree on. Nobody will move that unless there's going to be a lawsuit filed. Mr. Koshy wants to do one thing with it, Mr. Sachdev wants to do another thing with it. And whoever moves it first, the other one's going to file a lawsuit. Mr. Koshy wanted a distribution. He got a lawsuit filed against him. So that money, which is their biggest asset, is sitting there doing absolutely nothing for 6 years. And into the future, it's going to continue to do nothing because these two cannot agree on what to do with this major asset, and they're going to rely on decision by litigation, which is what we've seen with the 6 different lawsuits that they now have filed between them.
So you've discussed what happens if you lose. Let's briefly discuss what happens if you were to win. A Section 1432 gets kicked in. Judge may appoint a receiver to manage the company, and then the court may authorize a public sale or a private sale, correct?
That's correct, Your Honor. I think
So the judge would, if there were a dissolution, the judge would have the ability to say, I'm going to order a private sale, and I'm going to permit only 2 bidders, Mr. Koshy and Mr. Sachdev, and the high bidder wins and gets the company.
the court absolutely can do that. And not only do I believe the statute, 1432, allows it, but I also think this is an extension of the dicta in Brody versus Jordan. In footnote 7 of that decision, this court essentially said in the deadlock statute where the legislature has allowed involuntary dissolution as discretion of the trial court to impose, all lesser remedies are inferred, understandably inferred, as this trial court said. It said it in dicta, and I suggest that this court should extend that dicta to the deadlock statute specifically in this case.
Okay, thank you.
Thank you.
Ms. Mulligan, good morning.
Good morning, Your Honors. I'm Maureen Mulligan, and with my colleague Tim Pomerol, I represent the defendant Anupam Sachdev. I'd like to start actually where the court's questions left off, and that is that the most important part of this dissolution statute, 156D 14.30, is really the permissive nature of the statute. So the statute says that a court may, in certain circumstances, dissolve a company, but the statute never requires the judge to dissolve a company.
Except if it would be an abuse of discretion not to, presumably.
Correct, Your Honor.
So in that sense, it does. There are outer limits. It's not like this is a bound and unbounded field.
Correct, but if you look at the comments to the statute, the comments to the statute specifically state that if there are other remedies other than dissolution, and in particular it gives an example of closely held corporations, and it takes a look at closely held corporations and it says when there is an agreement between the parties that gives the parties an opportunity to separate, that the court should look at that. I mean, when we think about corporations, corporations are creatures of statute and contract. And those two things combined create the rules by which you run your company. So in this company in particular, Judge Henry found after the trial that, and it's shown in paragraph 3, I believe, of the findings of fact, he found that the articles of incorporation for this company provide a buyout procedure. One shareholder may offer his shares to the second shareholder can accept or reject, the second shareholder can counter, and if the two can't agree, then there's an arbitration procedure where they bring in a third arbitrator and they arbitrate the price. If after that price is determined, no one wants to buy the other's share, they have the opportunity to take the shares to the open market.
Let me stop you there. Section 5 says the corporation must choose an arbitrator.
Correct.
Basically, the person who wants to sell, the shareholder who wants to sell, can say, I choose Mary Moe as my arbitrator, and then the corporation gets to say who it wants to choose as its arbitrator. How is this corporation 50-50 going to choose an arbitrator?
Well, they could leave it to the first arbitrator. I mean, they could decide that
Is the other shareholder going to want to leave it to the arbitrator chosen by one shareholder? I mean, it seems that what you've described is a good explanation to why there is deadlock, because Section 5 can't work in a situation where they can't even agree upon who the second arbitrator will be, who will then choose the third arbitrator.
Well, I think that Section 5 can work, Your Honor, because what Section 5 is going to do is determine a value for the price of the shares and give the shareholder who wants out an opportunity to
Only as
sell.
if they can agree upon an arbitrator.
Well, they have not tried. The process has
Counsel,
not
isn't that the
been-
problem,
It's
the
not
inherent
looking
use of the
good.
word "they" in your sentences?
I'm sorry, I didn't hear that.
They will decide? I mean, once you start using that pronoun, we have a problem in this case, don't we, or in this corporation?
Well, my memory is that that each side chooses an arbitrator and those two
Okay,
choose
I
a
mean,
third.
Section
But I
5 Section
yield to
5
you and I agree
provides
with your
the person-
interpretation.
The stockholder who wishes to sell must identify an arbitrator. The directors, these two, then name another arbitrator, and then those two arbitrators choose a third arbitrator. That's the way Section 5 operates. Do you agree?
I would agree with you, Your Honor.
So the directors have to agree upon the second arbitrator in order for there to be an arbitrative panel to set a price.
And my point to you, Your Honor, is that it is speculative to say that that would not be successful because the parties have not made an attempt to exercise the arbitration procedure that's outlined in Article 5.
What have they agreed on?
What they've agreed on is that employees receive raises. What they've agreed on is to hire new salespeople. What they
Not
agree.
the people themselves upon whom,
That was a big fight, right?
there was a big fight about like who to hire, not whether to hire.
Well, what happened, Your Honor, is that the parties agreed that they could hire a salesperson, and the parties agreed that Mr. Koshy would hire that salesperson. And what Judge Henry found is that Mr. Koshy never made an effort to hire a salesperson, that he never came up with any candidates, so that it wasn't that the parties disagreed on who should be hired. What Judge Henry found is that Mr. Koshy never went out and found someone to come in and interview for the position and be hired.
That turned into a debacle.
No, I think that's a misrepresentation of what happened, Your Honor. So what happened here is it's clear that Mr. Koshy is not happy that Mr. Exafaris is working at the company. And Mr. Koshy made an allegation that Mr. Exafaris was trying to take over Mr. Koshy's role in the company, which is dealing with the Veterans Administration clients. But what the judge found is that no, Michael Exafaris was not hired to take over Mr. Koshy's role. Michael Exafaris was hired to take over Roger Gellen's role, who was the person at the company who was working on the VA projects. And in fact, Mr. Koshy and Mr. Exafaris worked together for a point in time until Mr. Koshy decided he didn't want to work with him. That was part of the discussion at the April 12th board meeting. And what they decided at that meeting, because of the Exafaris dispute, is that Mr. Koshy could go out and hire someone whom he wanted to work on the VA projects with him. He didn't do it. So what Judge Henry found is that there was not a disagreement about hiring for the sales job to be the interface with the VA.
So day to day, we have a pay raise in Salesforce. What else have they agreed on?
They have also, well, let me step back a minute. So in terms of, I'm assuming what you're really asking me is, how do you decide whether there's a deadlock or not? And do you have to look at what the
I just
parties
wonder,
are
what do
agreeing
they-
on?
Yeah, what do
And
they do
that-
every day? They sit in their office and they stew at each other.
So what Judge Henry found is that there was not a deadlock because the company was still functioning. And that's different from whether or not you find a threat of irreparable harm or irreparable harm for the company. And I think that the way, if you look at the comments to the statute say that you have to have a true deadlock, meaning that the company can't function because, as I said earlier, corporations are a function of statute and contract, and they're formed for a particular purpose. And if the company can perform its particular purpose, then there's not a deadlock in the function of the company.
So you think that Judge Henry used the right test, that whether the company can function and make money is the only test?
I think those are two separate things, and I think one thing that has happened in the briefing and in the oral argument here is that the function and the profitability are being combined to be one thing. So the company is functioning because its employees show up to work every day, its customers are still signing on with the company, and in addition to that, it's making money. So I agree that part of the comments to the statute say just because a company is making money doesn't mean there's not a threat of irreparable harm. So for example, if the employees were starting to leave in droves and the clients were starting to complain that they weren't getting the service that they normally get, might that create a threat of irreparable harm? It could, even if the company were still making money, but that's not the case in this instance.
Well, that could itself be irreparable harm, couldn't it? I mean, if people leave, or if there's a threat that people leave, that's, if people are thinking about leaving, why isn't that a threat of irreparable harm? I mean, because that would do damage to the company's ability to sell its product.
It might be in particular circumstances, Your Honor, but I think what is important in this case and in what Judge Henry found is that Mr. Koshy alleged that there was a threat of irreparable injury because there was decreasing revenue, customer dissatisfaction, supplier confusion, and employee concern, mistrust, and productivity. But what Judge Henry specifically found was that the evidence didn't support that. He didn't credit that. He said that's not happening. I don't find those threats.
Do you think that 2 years from now, that if everything is going the way it is now, that the company will be in existence? I mean, what's the prospect of that happening? It can't go on like this forever.
But the facts as they stand now as found by Judge Henry and his power of discretion,
Well, there's no harm now, but what I'm asking about is the threat of harm. It seems to be that may not have been given enough consideration here.
The threat of harm is to the corporation. When I heard the oral argument just before me, it seemed to equate the threat of harm with the disagreement between the shareholders. And the statute very clearly says that the harm has to be to the corporation. And if you look at the predecessor statute to 156D, that statute was phrased a little bit differently, where it said that you needed to look at the harm to the shareholder. So there may be disagreements between the shareholders. The shareholders may not like it. But why should one shareholder, because there are disagreements, have an order for the company to be dissolved when when the company is thriving and there are no threats? And I think that's what we have to really focus on here, is that Judge Henry found the threats that were alleged to be not credible, that they are not happening.
I'm not sure I read the words thriving in either brief, but what you have with this corporation is two fundamentally different views of what direction the company should go in. And they both might be eminently reasonable, but there's a deadlock. One wants to continue to foster the VA relationships, and the other wants to branch out into other areas. And then you have Judge Henry saying that the parties disagree on nearly all aspects of the business. And so the question is whether or not, if that's the finding, deciding not to have a dissolution is a abuse of discretion under the statute.
I think it's not, Your Honor. I think he could have found a deadlock and some sort of irreparable injury and still used his discretionary powers to not dissolve the company.
No doubt about it. The question, as Justice Link said, is whether or not doing so is an abuse of discretion.
This issue of that the parties cannot agree on, going back to the factual issue, what direction the company is taking, let's remember that this is a company that has developed software to do facilities management. And both of the avenues that the two shareholders want to take are still using this software to monitor facilities management. So what they're talking about is one of them wants to continue to market to VA hospitals and government entities. And by the way, the court found that the contract that allowed them to do that had expired. The other would like to continue to market to those entities as they have in the past, but also find new clients, because as the government contracts expire, they are less likely to be able to market to those entities. So that's the dispute. This isn't that one person wants to make yogurt and another wants to grow trees. I mean, it stems out of the same software that was developed for the same purpose for facilities management.
What happens going forward? Who wins?
That remains to be seen, but the issue is the corporation functioning? And here, the
Well, it's
facts are that the
functioning
corporation
because,
is
I mean,
functioning.
at some level, you can say, this must be one hell of a company with one hell of a product, that it is continuing to operate and has employees so loyal that they're managing in the midst of the War of the Roses here. But I don't understand how any of these decisions that are fundamental, how to spend $1.5 million, how to proceed with regard to marketing, how to hire people, what to do with Mr. Ex Officis, aren't you dooming yourself to basically saying we're just not going to do anything? We're just going to leave the status quo in place? And is that a viable course of action for a tech company?
I think it is, Your Honor. I mean, these are two parts of the statute, deadlock and irreparable injury. So the judge.
Or threat of irreparable injury, not.
Correct, Your Honor. Threat
You don't have
or.
to wait for the train wreck.
No, but in this case, what Judge Henry found is there is no threat. So despite the fact that there, in the brief and in the oral argument, the argument has been made that Judge Henry did not analyze whether or not there was a threat of irreparable injury, he did. In paragraphs 35 and 36 of his decision, he specifically looked at that. And on page 10 of his decision, he specifically looked at that. And he said that there's no threat of irreparable harm at this point in time because I don't credit these claims that are being made by Mr. Koshy. So in fact, in looking at the evidence that he found, he did not find a threat of irreparable harm. So although I appreciate
Was
the
he using
questions.
all the factors, though, that for example, other courts have suggested? I mean, we don't have, I mean, Judge Henry was operating in the absence, in a vacuum. There were no appellate decisions in Massachusetts on this point, as far as I'm aware, anyway. So I'm not really sure what guidance he had in terms of what factors were relevant to his decision.
But even if you look at the Parkway case, which was pre-156D and was based on 156B, which is an unpublished appellate decision in Massachusetts, even that court talks about the functionality of the corporation, which is the term that Judge Henry used. So I don't know what he looked at, but there were Superior Court decisions that come to similar conclusions. I mean, this is not a case where, for example, there are just two employees, or let's go back and look at the Parkway case again. I mean, in the Parkway case, there was all that company owned was a piece of property. And the two shareholders and the two directors couldn't agree on what to do with that piece of property. So their deadlock or their disagreement directly affected the ability to manage that piece of property. This is a bigger company, although there are
What year
two-
was that case?
I don't recall, Your Honor.
And it was under the old statute?
It was 2005.
there-
It's 2005. It was under the old statute.
And you said it was an unpublished?
It's 64 Mass Appeals Court 1111. It's unpublished.
Okay.
Is 156B, Section 99 still in the statute books?
No, 156D overrides 156B. So 156D is the result of the Massachusetts enacting the Model Business Corporations Act, which actually, if I could make one final comment on that, and related to the amicus brief, the Delaware statute is not an adoption of the Model Business Corporations Act, and Delaware has many more equitable powers for dealing with corporations than Massachusetts does. And I think that's reflected in the argument that's made in the amicus brief and makes it not directly on point to what this court needs to consider, because essentially what the amicus brief is asking is to make a policy decision as opposed to an interpretation of the statute that we've been dealt, essentially.
Okay, thank you.
Thank you.